Today we're talking about the intersection of divorce, family law, wills, and powers of attorney. So in this session, our experts will be sharing their insights on the legal implications of divorce and separation on wills and powers of attorney, focusing on the following areas. Wills and powers of attorney. What is a will and why is it important to have? Health and financial decisions. Why separate the two? Childcare and parenting and capacity issues. Next, we'll be discussing separation and divorce. What happens if there is a will and subsequent separation? What happens when there is a will and the parties are common law and separated? Can a separated spouse inherit under a will? And what happens when there is a will and subsequent divorce? Next, we'll learn about no will or inadequate provisions. They'll be discussing no will and then separated. Does the separated married spouse have any right to inherit? What happens when a married spouse dies and makes an inadequate will? Are any options to married survivors who are left an inadequate will? And are the options different if you are a common law spouse? And we'll also reserve some time for some Q&A throughout the presentation, as well as a dedicated Q&A segment at the end to answer audience questions coming in. The information provided in this presentation is intended to provide general information and should not be considered as legal advice. So now I have the pleasure to introduce today's panelists, starting off with Dr. Linda Ippolito, who is a classical pianist, lawyer, dispute resolution practitioner, teacher, and scholar. She is one of the founding and senior partners at the Toronto-based firm Sheridan Ippolito and Associates and the dispute resolution company Ensemble Solutions. As a lawyer, she has litigated, mediated, and negotiated over her 30-year career. Her practice is focused in the areas of family law and estates law and is now devoted to settlement-only work. Linda holds a PhD in law from Osgoode Hall Law School and teaches in the Executive Master's Program for Osgoode Professional Development. Linda has authored numerous articles and scholarly publications on dispute resolution topics, including the book Music, Leadership, and Conflict, The Art of Ensemble Negotiation and Problem Solving for the Palgrave Macmillan series, Business Arts and Humanities. Next, we have William Parker, and William is a trained collaborative family lawyer and an Ontario family law arbitrator and has taught prospective lawyers in the Law Society of Upper Canada's bar admission course in both estates and family law. Mr. Parker is also a member of the Estates and Trust and Family Law sections of the Canadian Bar Association, the Advocate Society, and a member of the Society of Trust and Estate Practitioners. He also has been a panel lawyer for the Office of the Public Guardian and Trustee, and Mr. Parker has been asked to and has spoken for the Canadian Bar Association's Ontario section on life and estate planning topics and has been on panels in continuing legal education programs in both family law and estates programs in 2018. In 2018, Mr. Parker received a diploma from the faculty and board of trustees of the National Institute for Trial Advocacy for having completed his intensive training program in Boulder, Colorado, in the art of family law advocacy, and NITA's American Bar Association's Family Law Trial Advocacy Program. Next, we have Golan, who is an associate lawyer and a certified mediator with over 25 years of experience. He was first called to the bar in Israel in 1996 and then called to the bar in Ontario in 2003. And Golan has extensive experience in representing clients and negotiation agreements as well as trial work. He also has experience in negotiating with the authorities to advance a client's interests and has represented clients at various levels of the court, including appeals. And last but certainly not least, we have Russell. Russell is the founder and senior partner at Russell Alexander Collaborative Family Lawyers, and with 25 years of experience, he uses his knowledge and expertise to serve his clients in all aspects of family law and helps them in coping with the difficulties of separation and divorce, the division of assets such as homes and pensions, and the calculation and enforcement of child and spousal support. He uses his experience to create unique solutions for each of his clients to enable them and their families to move forward and supports them through the transition of separation and divorce. And Russell has also authored 4 books on separation and divorce and is fully trained collaborative practice lawyer. And without further ado, I'm now going to pass it over to Russell to get things started.
Thank you so much. Let's run our first poll. If you have any ideas for future topics, please let us know. Before we make a start, let's find out a bit more about our audience. So let's see these poll results, Shannon. Okay, 42% lawyer, 33% lawyer, legal professional in a different area of law, 42 was family. Professional in another field, 8%, going through separation and divorce, 4%, helping a loved one, 10 law students today. Thank you for joining us. And other, you can put it in the box. So one more quick poll question, and then we're going to make a start. So who should have a will and power of attorney? You've got a number of options here. So we're going to give everybody a moment to let us know who should have a will and power of attorney. And we're going to go to our first audience question that came in advance. Is, are deceased disputes resolved in family court or somewhere else? Who wants to take that one? William? I don't think it's going to be family court, right? You usually need two to dance in that courtroom, but where are deceased disputes resolved?
Well, in the jurisdiction in which I typically practice, it's going to be on the estates list or the estates and commercial lists in Toronto. But if you're outside of Toronto, you're in the same court, Ontario Superior Court of Justice, typically with every other type of claim.
But if it's a unified family court, you're not going to be in the family court. You just be in the Superior Court.
That's right.
All right. Thank you for that, William. All right, let's find out what our audience thinks. Who should have a will? Married spouse, 6%, common law, 7%, people with children, 7%, elderly people, 6%. All of the above, 93%, pretty sophisticated audience here today. So let's talk about wills and power of attorney. Colin, what do we need to know?
Well, considering our audience is quite a bunch of professionals, we do not need to elaborate too much other than, everybody knows that a will is the legal document that allows a deceased to look after, or that somebody would look after his estate after he dies. So the idea is that it would be a legal document enforceable and that can be held in court if necessary. But the idea of the importance here is that, there's a lot of aspects that we try to avoid after our death, including saving time, saving money to our loved one, and definitely saving them the stress that goes along with the whole idea of looking after one's estate. So the importance of having this document is in the several aspects to it, including who's going to be managing my estate. A lot goes, I mean, we cannot say enough about the trusting relationship that you want to have with the appointed estate executor. That is the person that's going to be managing your estate after you pass. That's one of the major thing that you have to consider in making a will and a power of attorney. Similarly, when we're talking about we'll talk about that later, but that would be the power of attorney issue. But we want to make sure that we are able to determine who's the one who's going to look after the estate. We want to make sure that we give our estate the way that we want, and not less important, who we're not giving it to. Sometimes that becomes an issue as well. Whether you want to benefit a charity of your, a favorite charity that you are involved in, looking after your pets, having a say about your children, if they still need a guardian after you pass. There's other aspect could be, give instructions about your digital assets. So what's going to happen to that? And we would, I think, Russ, you were mentioning copyrights, of music relating to this topic. So, these are the type of things that could be looked after in a properly documented will. By having that document, you also potentially reducing a family dispute after you pass. That is, we all been experiencing that type of dynamic after people pass and leave a will or do not leave a will, which normally leads to that kind of situation, and it's more expensive not to have a will, because then you have to also argue about who's going to be the administrator of the estate. That's another aspect that you have to take into account. Funeral instructions is also one of the aspects that you want to consider when you're making a will, because that can give some instructions to your estate trustee. So nobody's going to be arguing about your burial plot and where it should be and what should be written on it. On all of the things could be looked after in that document. So these are in general, the importance of why everybody should have a legal will.
All right.
As everybody indicated, all of the persons that you listed in the poll, all those type of people need to have one.
Very helpful. Thank you, Golan. Let's see what our audience thinks. We need both a will and powers of attorney. And give everybody a moment to answer this question. Think another audience question that came in. Maybe I'll throw this one at you, Linda. What are the key elements that should be included in a legally valid will in Ontario?
Sorry, just had to get the mute off. So what I always do is I run down with clients just sort of the general structure of our wills, which I'm sure is similar for many people. So who do you want to be your executors? So you have to think about, who do I want to administer the estate? Who do I want as a backup? So that's one of the first categories in your will. The second thing you need to think about is, as Golan was saying, funeral arrangements. Sometimes, do you want to put in about organ donation, even though that would go into the data bank on the website for the ministry? And you may want to also turn your mind to appointing guardians for your children. That's something I'm going to mention when I speak in my section. And then, of course, to whom do you want to leave your estate? Making sure there's always backup people for the gifts, and then any kind of minority provision for people who might be underage. Family Law Act provision, very important to have in your will. And you have to make sure it's been witnessed by two people who are not beneficiaries or spouses of beneficiaries, or obviously spouse of the testator themselves, to make sure that it's legally binding.
So you just go to the shopping mall and find a couple random people, or what?
Well, ordinarily, the lawyer who drafted the document and probably their law clerk are going to be it. Some people like to do them on their own and say, if you want to, sort of step into a landmine, go ahead and do that. But
just having some fun with you. Okay, let's see what our audience thinks about this poll question. So do you need both a will and a power of attorney? Yes, 88%. No, 4%. It depends on whether the will is characterized as a living will or a last will and testament, 8%. Again, great audience response. Let's get into health and financial decisions. Why would we separate the two, Golan?
Well, just like we want to make sure that everything is going according to plan after we die, I think it's more important to know what's happening with your assets or with your health while you're still alive. So that is really the essence of a power of attorney, that we want to have a trusting person to look after ourselves, whether it's with respect to our property, whether it's respect to looking after our business, our banking, our property maintenance, etc. All of the things have to be looked after.
For our audience who may not know, there's a difference between a will and a power of attorney, right?
Absolutely. That's the reason we said that the one that we're answering about a living will versus a will, we're talking about the reference to the living will is really that power of attorney, that you're giving instructions and your wishes of how you want to be looked after while you are still alive.
So you're not dead yet, you're just incapacitated, and you need somebody to help you with the big ones are health and financial, right?
Right. So the incapacity also, I mean, if you're talking about a continuing power of attorney, then we're looking at somebody that can actually operate on our behalf even when we are not incapacitated. The major events that we want people to use a power of attorney is when we are not capable of doing the task ourselves, whether it's because of medical event, whether it's because of a temporary inability to be independent because of an accident, an illness, or whatnot. All of these things may require somebody else to act on our behalf. And that's really the importance of having a trusting person or persons to look after our assets and also make decisions regarding our health. And that's the reason that we sometimes separate the two, for power of attorney for personal care and for property, depending on on the choice of trustees that we choose or the attorneys that we choose to look after ourselves.
Yeah, and we've got some questions coming in from the common law. We're going to get to that, but childcare and parenting, what do we want to think about here, Golan?
Well, again, I mean, I think Linda just touched that in terms of making your wishes clear about who should be looking after your children if you in the event that you pass. It does not mean that choice is necessarily the best interest of the child. So that may be kind of competing interest, but at least it would carry it would be carrying a weight in the, when a court, if it goes to court, needs to make a decision about who should be the guardian for a child, or how a child should be looked after. So that's definitely one of the ways to ensure that your wishes are carried out, or at least being given appropriate weight, is to include that in a legal document, as we said. It's also, it's very, again, it's a matter of, we're talking childcare, we're talking about young children that are still in need of care. As they get older, sometimes their say is more important than what we have to say. So that's how we control that environment, but at least have significant weight to be considered.
So the provisions regarding parenting are your wishes. It's not going to be binding on a court. Court's still going to do what's ever in the best interest of the child, is what I hear you saying.
Right. That's the test eventually, is what's best for the child.
Right. Okay. So let's go back to our audience and get their feedback. Thank you for that again, Golan. What factors affect costs to prepare a will and power of attorney? And you've got a number of options here. And we're going to go to another audience question while we take a look at this. So are there any limitations or restrictions on power of attorney in Ontario? What powers do they grant and what powers do they not grant? Bill, you want to take a kick at that one?
Sure. Sorry, Russ, what the question again?
Are there any limitations or restrictions on powers of attorney in Ontario? What do they grant and what powers can they not grant?
Oh boy. Okay. So as Golan suggested, there's two types in Ontario. We've got a power of attorney for property, usually continuing power of attorney for property, and we have a power of attorney for personal care. In the context of property, a donor can grant the ability to a substitute decision maker, the attorney, the ability typically to do everything but make a will with respect to property. And then, of course, there's disputes in case law under, well, what's a will? Can an attorney settle, for example, a trust, and does it impact, the disposition of one's estate? So there's sometimes restrictions on those types of documents as well. In the context of personal care, there are some restrictions, most of which are escaping me, but I'm thinking about confinement. Typically, you're not going to grant the substitute decision maker the ability to confine you or restrict you to a particular location. Trying to recall Substitute Decisions Act, that's the type of thing where you would need a court order to address.
All right, thank you. Linda, do you want to comment on any of that?
On what an attorney can and can't do?
Well, the limits of, yeah.
Yeah. No, I think that Bill's kind of covered it. I mean, in the documents, you can be as detailed as you want in terms of what you want, what your wishes are that you want the attorneys to follow. But of course, the attorney's a fiduciary in terms of your finances, and so they have to prudently account for all of the money. And just an interesting factoid for those people who might see being an attorney as, you know, I mean, they are entitled to compensation, but that compensation, if they take it, is taxable in their hands as income. So an attorney who takes compensation would have to pay tax on it, but
Okay, thank you. All right, so factors that will affect nature of the assets is a big one. Legacy planning, all the above. So again, I think we've got a pretty sophisticated audience joining us today. Thank you for answering that. One more point for you, Golan, capacity issues. What do we want to be mindful of here?
Well, those of us who practiced in this area know that it is not seldom that we get into situations after a person passes away, and then one of the challenges of a will could be a capacity issue. That is, whether the person had the capacity to make the will in the first place. That's one of the importance of having a will done, is, while people are healthy and there's no issues regarding their capacity to make to record their wishes, and that they know what their assets are, that they know who the people that they want to leave the assets for. While the test is not so stringent in terms of what need to be done in order to, or what need to be comprehend in terms of the ability to make a will. Nevertheless, we want to avoid that. And one of the things that can be done is, for example, capacity assessments that some people do before the person is sitting down to prepare the documents. In other occasions, it's being done and then it's being challenged later on. Always challenging the capacity issues later on is always a more difficult task, to kind of looking back years sometimes to understand what was the medical condition of that person when he was making the will. And that's the reason that we always pressing on people while they're able to, and that that in our observation, at least, they're capable of making a will and a power of attorney without any flags being raised as to their capacity.
All right, let's go back to our audience with another poll question, please. How does separation affect future estate claims? Give everybody a minute to answer that. We had a question come in from our audience through the Q&A. Thank you. Can an attorney for care make a decision under MAID, so that's medical assistance in dying? That seems a bit much. Linda, I see you shaking your head.
no, they can't. And a person cannot even put into and have it enforceable a wish for MAID at this point in time. So right now, the way the law stands, a person who wishes to have medical assistance in dying has to consent to it. There's of course a whole bunch of paperwork that needs to be done, but they have to consent in the moment that it's being done. So they have, because there are two injections that take place. One is a sedative, and then you have to consent to that. Then you have to consent to the second injection, which is the lethal injection. And so that must be done in the moment by the person. So somebody else cannot consent to it for you, and you cannot even pre-consent in a power of attorney yourself.
That's a fine line. You're really threading the needle if you think of it as some of these conditions, right?
Yeah.
You have the capacity, but by the time it comes to the process, you may be too far gone, right?
Right.
Like, you'd think the will would be a safeguard to still respect your wishes.
No, because I mean, I don't want to take up the time. But I actually had a client who the only thing he wanted was made. He was very, very specific. He had a brain tumor. The paperwork was filled out. The doctors and so on, practitioners had filled out saying, yes, he was entitled to have it, which you have to meet a threshold there. And then it was all put in motion, but he sort of lost capacity on a temporary basis. He would be in and out of lucidity, and he was not able to then give the final consent. So his sister was beside herself because she said, oh my God, the only thing he asked me for was this. What ended up happening was people then had a vigil to sit near him to see if he would come out of his sort of semi-coma state. He did. And when they said to him, do you want the maid? He said, no. So this was a guy who was firm. This was what he wanted. It was the only thing he wanted when he could verbalize. But then when push came to shove, he changed his mind. So it's, you know, it's not really a thing you can pre-agree to, because you may in fact change your mind. Something, you may have a philosophical, you know, epiphany and just decide this is not for me. So it's got to be really in that last minute. It's fascinating.
Tough on families for
Yeah.
sure.
Yeah.
One question I just want to get back to, we all had, I've had clients come in and say, okay, I've got an elderly family member in the hospital on their deathbed. Can you come do the will for me? And I'm not going to do it. Like, it seems like a lot of liability attached to that in terms of perhaps family members who get written out questioning capacity. What's your advice for the bar when you get these calls to go into the hospital and assist somebody? Do you want to take a crack at that, Bill?
Oh, for sure. My advice would be, if you're prepared to accept the retainer, which is a choice, you know, or refer it to someone else, if you know, it's your decision. But when you choose to do that, you're going to do it as you normally would. You're going to try and ensure that you're meeting with the person, you're meeting with them alone, you're taking instructions from them, you're trying to confirm their capacity, you know, to make sure that they know the nature and extent of their assets, they know those that society would expect them to benefit, and you can appreciate or not if they're making an orderly disposition when they give you instructions. You're going to take great notes, and you want to make sure you ask probing questions. If you have doubts about capacity, what just keeps ringing in my ear is, the late Rodney Hull saying, yelling at me, you do the will, and you let everybody else, deal with it later. If you say, well, I'm not sure if the person has capacity, I'm not going to do it. Well, then again, you're just doing exactly what you've said, Russ. You're opening up yourself to liability to disappointed beneficiaries. If you have the time and the luxury of getting medical, input, well, you're going to try and get it, but often you don't have the time to do that. So again, it's you're accepting the retainer, you're doing everything you can to confirm capacity, or you're just taking really great notes. And sometimes you're even going to talk to independent sources to at least try and get information that, about assets, for example, about circumstances, so that at least when you're talking to the testator, you can verify some circumstance to get some appreciation of that. But hopefully that's a helpful comment.
You want to make sure you get a retainer that's going to cover your law pro deductible as well, right? In case things go wrong. All right.
Before you go there, Ras, I just an add-on, because in that kind of situation, what I do, everybody has their phone with them. It's easy to take a video of your interview. If somebody needs to review it later on and decide whether or not the person had capacity or knew what he was talking about, I find it very helpful to have a video taken of the interview, and it's better than the notes in my view, but that is my practice when I'm dealing with this kind of iffy situations.
Yeah, great tip. Okay, audience questions and answers here. Separation non-void 16%, doesn't affect future claims 20%. It depends. That seems like a lawyer answer. 34%, depends on period of cohabitation, 12%, and other. So this leads us into separation and divorce. Linda, what do we need to know?
Okay, so great answers to the question. First of all, it's important to note that there have been some significant changes to the Succession Law Reform Act as it relates to property rights of separated spouses. So there was something called Bill 245, Accelerating Access to Justice 2021, and that came into effect on January 1st, 2022, and it made a number of changes to the SLRA. So as of January 1, spouses that have been separated but not divorced for at least 3 years, have been separated for at least 3 years, or spouses who have a valid separation agreement or court order will be treated the same as divorced spouses. And I'm going to talk about that a little bit later, but just cutting to the chase on that. So if a person is divorced, all of their claims are canceled under the will. So if not their claims, but their entitlements under the will are all canceled out, and the will is treated as if the divorced spouse had predeceased the testator. So the same thing is now going to happen with separated spouses after a 3-year period, if they don't have a separation agreement otherwise. So this means that the separated spouse who has been designated as an estate trustee or a beneficiary in a will is not entitled to those benefits under the will anymore. That wasn't the case, as I said, before January 1st, 2022. So previously, unless the spouses had a separation agreement with specific provisions for property rights, the separated spouse could still make a claim against the estate of the deceased spouse or take what had been left under the will. So now the situation is as follows: absent a separation agreement, within the first 3 years of separation, an existing will is not revoked or invalidated, and the separated spouse remains entitled to any gifts that were left to him or her under the other spouse's existing will. So that's why it's imperative that separated spouses change their will immediately upon separation. Otherwise, the unintended consequences are that the separated spouse, if he or she was named as a primary beneficiary, which is what happens in most cases, they will take the entire estate if the other spouse dies within those first 3 years of separation before a separation agreement's been signed or a divorce order's been obtained. So people are encouraged to change their wills upon separation and to change their beneficiary designations, particularly if they're involved in litigation, which can drag on for a protracted period of time, with other issues often eclipsing things such as estate issues. I just make a note, however, that often when people are in the collaborative process, there's a commitment not to alter status quo in relation to some beneficiary designations related, for example, to health benefits and life insurance, where there are support obligations. But absent those concerns, I would still recommend that these things be changed. And if an issue arises as part of settlement negotiations, such as security for support, you can always add someone back in as a beneficiary. But if you forget to take them out, they're going to take, and that might not have been your intention.
So practice tip for our family lawyers out there: new wills and power of attorney when your clients come in the office. We're actually put that right in the initial reporting letter. We tell them at the front end. So if anything does happen and they don't follow our advice, then at least they were informed. Really, really great tip. Okay, so what happens when there is a will and the parties are common law and then separate? And then are separated. So we'll just drill down one more level here. How does common law affect what we're talking about?
Okay, so unless unless somebody's a married spouse who will be, treated as divorced after those 3 years from separation, there's no such thing, of course, as a divorce for a common law spouse. So the common law spouse who's named as a beneficiary in a will, or who's named as a beneficiary on an investment or a pension or a life insurance policy or a tax-free savings account or any other instrument on which you can name a beneficiary. If they've been named on those things, they're going to get them. And if you don't make a separation agreement that has all the releases in it, if you just separate and that's it, that common law spouse is going to take, because the new changes that come into place do not apply to the common law spouse because you can't divorce. However, it will apply if you make that separation agreement within the 3 years. So you have to be really careful, make sure you get the separation agreement signed. A lot of times common law spouses think, oh, we don't really have any obligations with one another. And so if they're kind of your kitchen table type of a couple, they may forget. And so you want to make sure that you do get the separation agreement because they would have the same kinds of entitlements if that doesn't happen. Again, this 3-year period comes into play. But again, the rule of thumb is,
Can I
yeah,
just stop you there? Because
Sure.
now I'm getting nervous, right? And I'm sure a lot of family lawyers are. So we have the standard releases, divorce mates got precedent releases that we throw in there. We put the release in the separation agreement, but the clients don't actually follow through with the insurance provider or whatever the beneficiary is. Will that release stop that asset from flowing, or if you don't rename the person, it's not gonna help?
those are, there have been some pretty classic cases, but I think, where people have either were or weren't named in insurance policies. But I think those ones related to where somebody was supposed to provide security for a support obligation. But I mean, if you've named somebody as a beneficiary under a life insurance policy, and then you sign a separation agreement which has the release in it, that release should be usable to cancel out the beneficiary designation.
So the boilerplate release should be good, but just to be on the safe side, actually list the instruments or whatever you're trying to cancel out.
I would just make sure,
name 'em.
yeah.
Yeah.
As part of your follow-up with clients, always say to them,
Right.
look, do you have these things? Have you canceled? And make sure as part of the follow-up that they've done it, because they usually just sign the agreement and ride off into the
Such
sunset.
an easy thing, you get the agreement signed, you send a reporting letter, you close it out, but there's all these additional steps our clients should be taking to make.
We
sure-
often, we
Yeah,
often follow up with them by telephone to make sure they've actually done it. I
Yeah.
had a case where, it always says, this cancels anything that was made before the date of the agreement.
right.
Okay, I had a guy who went off and he did some beneficiary designation after the date of the agreement. And he named the spouse on purpose. Those, sometimes they can mean that, or sometimes people think, oh, we don't need all that stuff in the agreement. Why do we need that stuff in the agreement? And maybe it's a homemade one, they cross it out. So they haven't put in that thing that says this cancels all designations including in a will made before this agreement. And I had one where my client ended up getting $1 million in a life insurance policy because the guy left her on it and didn't take her off it.
Yeah. I bet you his new partner didn't like that.
Thankfully, he didn't have a new partner at
Okay.
the time, but yeah, okay.
All right, so let's just drill down one more level here. Can a separated spouse inherit under a will?
Yeah, absolutely. So for all the reasons that we've already talked about, regarding both the married and the common law spouses, yes, they can inherit under the will. But now with the change in the law, if it's after the 3-year mark, then they'll be treated, and you make a separation agreement. So if you make a separation agreement, you're good. If it's after the 3-year mark, they'll lose their entitlement. So you have to just be careful. I just wanted to say that you may intentionally, as I say, put the separated spouse in your will in order to comply with a term of the separation agreement. So a new will may be made with money being inherited in the future to satisfy a support obligation or an equalization payment, or even to grant something like a life interest in a property if someone's permitted to stay living in a home after the date of death. So
you see a lot of separation agreements have life insurance provisions to secure support. So
right.
You need to make a will consistent with that provision, I would imagine.
That's
Or
right.
that part of the will would be void.
Yeah, and exactly. And sometimes people will say, well, I've put it in my will, but wills can be changed. So if something is an irrevocable provision in the will, or if, as you say, somebody does something in their will that's contrary to what's in the agreement will prevail.
Yeah, and
So-
we've done separation agreements with some legacy planning, so people repartner, we want to see proof that these earlier provisions in the separation agreement are going to be binding on their new partner. But let's go to our audience. It's been a while. Thank you for that, Linda. How does a divorce affect future assets? And we're getting lots of questions coming in from our audience. Thank you, audience members, for sending in your questions. One that always seems to get people fired up are pets, right? So can you can you have powers of attorney dealing with pets? And also, can you put your pet in the will? I assume the answer is yes, if we treat pets like property, but do you see a lot of concern about pets when it comes to wills and power of attorney? What's your experience been? Linda?
We've had wild and wacky stuff to deal with pets. And
Yeah.
people will put things in about their pets. They'll appoint someone that they want to care for the pets, or they'll give cash legacy to go with the pets.
Yeah.
And that will happen a lot. We had one lady who left us, she had no children, she had no relatives, so she left everything to the pets. So great gobs of money went with the pets. And there was some painstaking, search for the appropriate person to care for the pets. Well, didn't you know that those pets mysteriously passed not that long after the lady had died? And guess
How-
where the money went,
How
right?
convenient.
Yes.
Bill, I guess you deal with pets as well, or no?
Yeah, I agree with that. Yeah,
Just
wild and
common.
wacky provisions, but understandable for pet lovers.
Yeah. They're like children, right? If you don't have kids. All right, let's see what our audience thinks here. All claims are void once the divorce is in place. 42%. Doesn't affect 14, depends, again, for 24%, period of marriage, 9%. So quite a variety. Thank you for answering that. What happens, Linda, when there is a will and a subsequent divorce? What do we need to know?
Okay, so final word goes to wills and divorces. So everybody asks, is the will invalid? What happens to the gifts that you've left to your now ex-spouse? What happens if you've named your ex-spouse as your executor? So divorce on its own does not revoke or invalidate a will. A will itself remains valid, but as I said at the front, any gifts you might have made to your spouse are canceled out by the divorce, and the will is treated as if the divorced spouse had predeceased the testator. The estate then passes to an alternative or contingent beneficiary or beneficiaries, and your former spouse will also no longer be your executor, trustee, or guardian. The word guardian brings me to children and your will, which is something Golan was talking about. But in a will, you can appoint a guardian for your children. So the Children's Law Reform Act, Section 61, allows for you to do that, but with some restrictions. So it's important to remember that unless you have sole decision-making yourself, your surviving spouse, so the other parent, has the right to be the guardian of the children over anyone else, unless, number one, there's already a court order dealing with decision-making and parenting that makes the other spouse sort of out of the picture or restricted in some way, or if a court were to find that it's in the best interest of the children that a non-spouse who you've named in your will should in fact become the guardian. So remember, naming somebody in your will as the guardian of children is a temporary appointment only. And within 90 days, the named person has to file a court application to obtain an order granting them decision-making authority in relation to kids and to have the rights and responsibilities of a parent. You also need to obtain an order, maybe, to become the guardian of the child's property. So two different things. When you name somebody other than the parent as the guardian of your children and of their property, the same three restrictions apply again. You have to be the only person entitled to guardianship yourself. The person you appoint must consent, act as the guardian, And again, the appointment is only effective for 90 days. So the court will choose the guardian based on best interest of the child, their relationship with the children, applying the relationship of the person who's applying to become the guardian, and the relationship of the children with any other family member. So the court's going to look at all of who's most closely connected to the kids. In the case of guardianship of property, as between a parent of a child and a non-parent of a child, the parent has preferential treatment to be the guardian of the property of the child, and whether or not a formal guardianship of property order is needed depends on the value of the estate which the child is entitled to. These are all really important things to be aware of in relation to death, divorce, guardianship of kids, and you'll often see people make provision in their separation agreements in relation to wills and future guardianship of children, but that is not necessarily the end of the story, because of course the court has the final word on that, because they still retain their parents' patriae jurisdiction.
All right, thank you for that. Final poll question. We've got audience members asking to hear from Bill. Bill's coming. We've got Bill coming. Bill, question for you while we give the audience a chance to answer this. What is the role of an executor in Ontario, and how do I choose the right executor for my will? What advice or tips would you give on that?
So what is the role of an executor?
Yeah, and how should the client choose one? What would they?
Okay, well, yeah, the role very simply, right, is to initially, if you're appointed, take care of the body, right? Address, funeral cremation arrangements. And then again, very simply, it's to collect assets, to pay all debts, and to distribute assets in accordance with the terms of the will. Choice, lots depends on choice. And generally, do you know the person? Do you trust the person? And are they going to carry out, your wishes? Choice could be, where do they live? Are they resident in Ontario? Are they, resident elsewhere outside the country? Choice could impact or get you thinking about more than one executor, having two people to act. I particularly like that when we've got minor children and we've got a caregiver, if you will, or a parent with decision-making responsibility. I like to have somebody else perhaps having hold of the trust funds for the kids. But the one that is the tough one for me very practically is when you have 3 kids and the parents come in and they say, I want all 3. And I keep thinking of some minds that were much brighter than me that keep saying you want to leave a legacy that you're proud of, and you don't want your kids fighting after the fact, and appointing 3 kids is just not a good idea. And clients say, thanks for your advice, I'm going to appoint all 3 anyway. But those are some simple things about choice.
Great tips, thank you. What happens if a person dies and they don't make adequate arrangements? Let's see what our audience thinks of this poll. And then we're going to, I don't know what, did we get our poll results up? Here we go. Thank you. All right. So the answer, according to our audience, both dependents and children and dependent spouse make a claim against the estate, 98%. No will or inadequate provisions. Bill, what should we consider when we're thinking about this?
Sure. I love the picture, by the way. It's just, don't make adequate arrangements, oh no, it's a mess. So I think I kept thinking this was a trick question, but I mean, no will, separated. Does the separated married spouse have right to inherit? I think that comes back with, what Linda said. It's a yes, but. So yes, you've got a right to inherit, but if the spouses were living separate and apart, as a result of a breakdown of the marriage for 3 years, then no.
Okay. So what happens when married spouse dies and makes inadequate provisions?
So,
sorry, yeah, that's right.
So then, in that situation where let's say there is a will, and it's just insufficient, the court in Part 5 of the Succession Law Reform Act has the ability to order, such support as may be adequate and proper out of the estate of the deceased person. And just like the best interest test for, parental decision-making responsibility, there's a complete shopping list set out in Part 5 that gives the court an extraordinarily broad discretion to make the orders that it thinks proper. Frankly, it could be straight lump sum, it could be lump sum with periodic payments, it could be an annuity-like arrangement, it could be possession of property, right to reside for the rest of life. So you're into that assessment by judges. Unfortunately, there's mandatory mediation in estate-related litigation in 3 big jurisdictions in the province. There's not really a ton of cases. And for the family lawyers that are out there, there's some divisional court authority that you can throw in the SAG guidelines to try and figure out what perhaps parameters would be, particularly in former spouse fights as against, new spouse fights, if you will, after the death of the spouse. So certainly there's the ability to claim, dependence relief, which is akin to, the spousal support concept, completely different, again, assessment. Although spousal support seemingly has creeped in with this SAG assessment in a couple of decisions. And you still have, you're still looking at Section 6 in the FLA to see if you don't like the will, you can elect for equalization as well.
Okay. So what options are open to married survivors who are left with an inadequate will?
That's
right.
Yeah, that's the do I want to have a claim akin to support, which is the dependence relief claim under Part 5 of the SLRA, and then in vis-a-vis property, you've got Section 6 in the FLA to make a claim for an equalization payment. And the carefully read the subsections in 6, because it depends, at least Linda was talking about, what's the equalization payment? Once you determine that, how are you considering assets that have specific beneficiary designations that go to the spouse, the claimant? So you have to.
What's the date of separation? Your date of death?
Yes.
And you're not going to the family court. You're still in civil court.
You're still in Toronto with a dedicated estates court or otherwise civil. Now, I think that technically it's the day before the date of death is V Day.
You may not be drawing a judge
yeah.
who does family law.
Pardon me?
You might not be drawing a judge who does family law.
Well, I have had situations where separated spouses have been in family court, and somebody dies, and we've actually obtained orders just to continue it in family court, which is frankly a good thing. But the thing to be careful of, Toronto especially, you're on the estates and commercial list. You're dealing with judges that are dealing with billion-dollar disputes. The one house estate is not it's obviously meaningful to the clients, meaningful to the lawyers, but not family specialists, extremely bright people, but they don't have a lot of time to deal with it.
Right. Okay, one more question I want to get in here if we can. Are the options different if you're a common law spouse?
Well, you are still going to come within the definition of a spouse in the Succession Law Reform Act to claim dependence relief, but now you're not in Part 1 of the FLA. So you then have the what may not be, again, satisfactory in terms of predictability, but you have the typical unjust enrichment, constructive trust, purchase money resulting trust, quantum merit, promissory estoppel type claims available to be made.
All right. Well, thank you so much. I think we're going to go. Oh, look, Shannon's back like magic. Q&A, Shannon, and then we're going to wrap this up. I can't believe it's 1 o'clock almost already.
Wise. But we do have a few minutes here to answer some audience questions. Just first of all, want to thank Bill, Linda, and Golan again for joining us on the panel today and sharing your knowledge and expertise with our audience. And just want to thank all of our audience members for all of your participation, all of the questions that came in as well. We're very grateful to have a large audience today. So unfortunately, weren't able to get to all of them, but we're going to do our best to get through as many as we can in the next couple minutes. And we hope that a lot of them were answered throughout. And so first question I have here is, are there any tax implications or considerations that individuals should be aware of when creating a will or power of attorney in Ontario?
Bill?
Yeah, my jaw dropped. Yeah. Well,
That could be a whole nother hour, right? That question.
Yeah. I mean, absolutely. And the challenge sometimes in your complicated planning for the second relationship, you're actually trying to assess what's the equalization payment, what's the minimum that's going to satisfy proper and adequate support, and you need to know the basic tax ramifications. You need to understand the principal residence designation. You need to understand RSPs, how they're taxed, RIFs, how they're taxed, capital gains. Absolutely.
All right. Maybe one more, Shannon. That was a doozy.
Thank you, Bill. The last question here is, can you explain the process for challenging a will in Ontario and what grounds are typically required to contest a will?
Linda, Golan, you want to take a crack at that one?
Wow, that's another session by itself.
That's another hour, right?
Right. Well, normally what you would bring is an application to the court challenging the validity of the will for various grounds. Most of them are, like I said earlier, could be capacity, could be undue influence, could be a formality that was not followed properly, so the will was not properly done. The witnesses may not be appropriate witnesses in the formation of the will. The language that may be unclear in the will, so some provision may be challenged as opposed to the entire will. You may just challenge a provision for the ambiguity of the term and so forth. That's normally what is being brought forward in most of the challenges. Like I said, the undue influence and capacity is one of the big ones that comes up often in this scenario. And by the way, because we have a lot of professionals in the audience, and just to add, Linda was explaining about the property of children and so on. I think it's important that people will know that the public guardian and trustee's office have to be notified and involved on many occasions in this scenario when we're dealing with children's property. So if you start an application, you have to notify and you have to give a notice to the office of the public guardian and trustee.
Thank you again to all of our panelists for joining us today and to all of our audience members. As I mentioned at the beginning, please feel free to email me with any general comments or questions on our virtual event series. It's shannon@russellalexander.com.
Thank you so much for your time today, everybody. I hope you have a good afternoon.